that will go against the most cardinal rule of a trial, the right to be able to rebut the matters which have been alleged. My lords, turning to the next issue of this irregular practice of a party strategically placing himself as a petitioner and having another person as a fourth respondent, we are sandwiched between two petitioners in essence, because in my submission, the fourth respondent is in truth a petitioner at the same level as the petitioners before you. It will not be possible, my lords, to be able to answer two petitions, one which we have answered to, and another one which cannot be answered to. My lords, it is very, very uncommon to come across the situations which is before you, come to the court, read as much as this party has done, and I have found an authority from India. There is a supplementary list of authorities. I found fairly late last night an authority from the Supreme Court of India. This is in the supplementary list of authorities we found this morning. And, my lords, it is at paragraph 9 of that Supreme Court decision that they define the effect of withdrawal from an electoral contest. It's a very interesting sentence, very brief. The fact is that the withdrawn candidate is no candidate at all. He has simply gone out of the picture. Withdrawn candidate has simply gone out of the picture. My lord, it is common ground, and this is a common ground, that the candidates under this assembly or coalition of political parties called NASA withdrew their candidates from the fresh presidential elections. That is common ground. Their involvement, therefore, in this context cannot be understood in any reason other than that of coming to, so to speak, confuse issues, prolong the trial, have another advantage of throwing challenges and political rhetoric in this contest. That, my lord, is not the point that we should be dealing with. We should be dealing with a petition which can be regularly answered and regularly prosecuted. In the situation that we are in, that cannot be had because, my lords, as I have indicated, it will not be possible for us to have a fair hearing in whatever color of that fair hearing expectation. My lords, I conclude by requesting the following. Please strike out the fourth respondent from this contest. The fourth respondent, if they so wished, could have filed a petition. As a matter of fact, the latitude in Article 140 is very wide. It talks of any person can file a petition. A time period is set out for when to file that petition. The constitutional timeline is 7 days. What you now have, my lords, is a disguised petition filed outside the constitutional timeline of 7 days. I come from the school of thought, my lords, that these timelines are not made in jest. They are made to be complied with. Because the minute we do not comply with these constitutional imperatives, then we send a signal that these timelines are made for jest. This is a petition filed hopelessly out of the 7-day period. My lords, it is not a petition that should be entertained at all. The second request I make of you, my lords, is that the pleadings filed by this coalition be expunged from the court record. They are unnecessary. They will confuse us as we move along. There are lots of video recordings, a lot of internal memos. As a matter of fact, they have more internal memos from IEBC than the memos I applied to be struck off. They appear to have been more in bed with IEBC than the petitioner. They have more memos in their petition than the ones I applied to be struck off. I am not applying to strike off those petitions, memos. I'm applying to strike out everything they have filed. My lords, nothing less in our very respectful submission will be sufficient, because to allow this to go on, my lords, would be to have a situation where there cannot be a fair hearing. And before I sit down, my lords, when my worthy colleagues take to the floor, the question they ought to answer is as follows. Now that they have filed these pleadings at the close of the time the pleadings have been closed, how do they expect us to answer them? It's as simple as that. Because if they have no answer to that, my lord, then the only way out is that the door be shut and they be told there is no process, no system of allowing a complementary petition. This is really a complementary petition to complement the petition that was filed maybe within time or just slightly out of time. I'll therefore ask you, my lords, to strike out everything filed by this coalition so that we can have a regular trial before you. My lords, that will be all. There are authorities that the authority I have referred to is before you. The relevant part is at paragraph 9. That will be all, my lord.
Thank you. Thank you, Mr. Ngatia. Yes, Mr. Mwangi.
Yes, my lord, I'm going to start my response on a very unfortunate note. First, by reading to you.
My colleague has pointed out to me, it's Rule 11, not Rule 9.
Okay.
Yes, Rule 11.
Okay.
Sorry about that, but for the record, it's Rule 11.